Welcome back to the Money Club. Now, here's the question for you. Who should be listed as the owner of your investments? Now, if you're married, you probably say both you and your spouse. Well, maybe and maybe not. Joint ownership is not always the way to go. The editors of Money Magazine report that making the right decision regarding ownership of your investments could have a profound impact on your estate.
This is the deed where you and your wife Teresa transferred the property to your 3 children.
If you're married, you've probably spent hours talking about where you should put your money, but less time considering in whose name your assets, like your home, should be listed, you, your spouse, or both. If your investments are owned jointly, you and your spouse have the security of knowing that should one of you die, your property and investments pass on to the survivor without having to endure the time or costs of probate. But joint ownership of your investments, including your home, isn't always the best way to go. New York attorney Howard Atlas says couples with children in particular should consider other options.
Since the house is the most valuable, important asset that most people have, they like to leave that property to their children. Transferring a property with a life estate enables the parent to have the right to live in that residence for their lifetime. And what it also accomplishes is that it will avoid probate and, furthermore, protect that asset in the event that parent or parents require nursing home care, because at the parent's death, that the life estate would extinguish, and any claim that Medicaid may have on that property would also extinguish.
Sal and Teresa Longobardo, a retired couple living in Long Island, New York, recently transferred ownership of their home to their daughter Pat and her 2 brothers. Sal and Teresa can remain in their home for the rest of their lives, but the house will belong to their children. When Sal and Teresa die, not 1 cent of estate taxes will be owed on the home.
My sister died about 2 years ago, and she got into this probate thing, and we had to wait almost 3 years before we even heard anything about anything. And Medicaid took everything these people had, everything. They took the cars, the house, the little money that they had left them with nothing. They were destitute just because they didn't have their estate planning. And I would like you children to have everything we've got after we're gone, without the hassle and trouble and the heartaches that I went through. My dreams are in this house. The kids grew up in this house. The parties were in this house. I got to give it back to the kids.
There's one other smart reason to hold your investments in a trust in your children's name rather than own the property jointly or in your own name. You can protect the investments from creditors. Frank Graziadei, a litigations lawyer, says that in most states, if you own property jointly and one of you is sued, creditors can come after all your jointly held investments, no matter who owes the money.
Let's assume that you're in a car accident, and let's also assume that your real property is owned both in yourself and your wife's name jointly. If you had the wisdom and had previously set up a trust account for your children, your assets could be protected. So the judgment creditor, let's assume, obtains a judgment against you of $1 million in excess of your insurance. And today, everybody sues everybody for at least $1 million. The result would be your children's assets for their college funds or whatever would be protected.
The most you can transfer to your heirs without triggering estate taxes is $600,000. You can easily exceed that amount if you own a home, stocks, and mutual funds. If so, you might want to consider the option called tenants in common. Assigning your assets separately under this arrangement, you and your spouse may bequeath $600,000 each, or $1.2 million total, tax-free. Of course, before you make any decisions on who should own what and how, be sure to consult an attorney specializing in estate planning, because the right moves now can save you or your heirs thousands of dollars later.